President, please be seated. The chamber is now back in session. A while ago, the chamber received an email from the co-prosecution to make an observation on the OCIJ related to a civil party. And now I give the floor to the co-prosecution. Please make your observation short.
Thank you, Mr. President, Your Honors, Counsel. The co-prosecutors wish to make it clear on the record that we believe that there is no basis for the witness to be testifying not using his full name and real name. It is our understanding that the witness has no problem with his testimony being public and his name being public. If he objected, I certainly would agree that his name should be protected, but my understanding is the gentleman is not seeking to keep his identity private. I understand the court has received other communications, but it is for this trial chamber alone to decide under the law whether the presumption for a public trial should be overridden by good cause, such as the protection of a witness's privacy or safety. This witness has no need, as far as we've determined, as far as anything that I've seen submitted to the court, to have his privacy or safety protected. He's willing to testify in public. And as a principle throughout the trial, I think all proceedings should be in public, absent good cause that this chamber finds. It has to be found by this chamber based upon reasons that this chamber knows of and can give on the record. Thank you. And I believe the civil party lawyers are not in disagreement with me.
President, the floor is given to the lead co-lawyer for civil parties.
Merci, Monsieur. Thank you, Mr. President. First of all, we're not talking about a witness, but a civil party. And we believe it is important to recall that there is a difference between a witness and a civil party in this chamber. Next, we have also looked at the memos of the OCIJ and the responses by the chamber on the disclosure of materials from cases 3 and 4 and the classification that was proposed. On this issue, we would like to add our understanding that the fact that the OCIJ asked the chamber to respect a certain number of classifications. The parties had the opportunity to express themselves regarding these classifications, and at the end of an oral debate, the chamber decided to adopt the proposal of classification that was put forth by the OCIJ. And it is following this recommendation and accepting the criteria of the OCIJ that this civil party, at this time, is testifying under a pseudonym without his real name being revealed to the public. So we are relying on the judgment of the chamber, understanding that this civil party may not have a problem with his identity being revealed, since he already testified in case number 1, and that there are certain elements concerning his identity available on the website. The video, the transcription, and the audio file are currently available on the court's website. Therefore, the civil party has no objection as to the anonymity being lifted today so that he can testify under his own name. Now it is up to the chamber to see if this situation corresponds with what was decided concerning the disclosure of materials of cases 3 and 4.
President, the floor is given to the Defense Counsel for Nguyen Chi.
To ask questions of the civil party or to respond to this issue? As a general principle, we would agree that all proceedings should be public.
President, we need your response.
Just to simply say that as a general principle, we would agree that all proceedings should be public, but we have no other observations on this matter.
Kong Samon, thank you, Mr. President. I would like to give my observation regarding the publicity of the proceeding. It is necessary for the fair trial and the ascertaining of the truth. I also noticed that the civil party in this courtroom, he has his lawyers who give him advice on the legal aspects of the proceeding. The publicity of his testimony here can be advised by his counsel. Therefore, if the civil party wishes to have his testimony public in this courtroom, there is nothing concerning. And for the status between civil party and witness, can be differentiated. Therefore, it depends on Mr. President for your own wisdoms. President, thank you, Counsel.
Merci, Monsieur le Président.
Thank you, Mr. President. First of all, I think it is clear following these observations that this hearing is public. We have made it public. The only question that was brought up by the co-prosecutors was the use of a pseudonym. And I must admit that this is an issue that seems a bit curious to me at this stage of discussions. I wonder why we awaited the testimony of this civil party to raise this question. It seems to me that the conditions of the hearing, whether it's the civil party or the witness concerned by materials of cases 3 and 4, are known at the point when the OCIJ renders their decision, which sets the conditions for the hearing of the witnesses and civil parties concerned. So at the outset, we know if a civil party can be heard with or without the use of a pseudonym. The second point is that these conditions are set not necessarily as a measure of protection for the civil party or witness, but also in order to maintain the integrity of the investigation. And we have decided that this measure was raised by the OCIJ and the Chamber would not modify it. So my question is, does the Office of the Co-Prosecutors or any other party have submitted these observations to the OCIJ? And if so, when? And they asked for there not to be a pseudonym. At this stage, it would have been appropriate for the Chamber to make itself heard on this subject.
Thank you. I believe that frames the issues very well. First of all, I cannot say off the top of my head that we submitted on this issue. We certainly did not suggest a pseudonym to OCIJ. I'd also say regarding the timing, I don't think the issue is what OCIJ decides. It's what Your Honors decide for two reasons. First of all, the pretrial chamber has made clear in a ruling, which I should have mentioned earlier, D309/6. D309/6, an appeal from the co-prosecutors about prior rulings of the co-investigating judges, that the co-investigating judges cannot impose conditions affecting the publicity of the trial. That is solely a matter for the chamber before which the hearings are taking place. They can, of course, provide suggestions with reasons. In regards to litigating this issue of pseudonyms before the OCIJ, another reason it's not appropriate is that most of the parties, or half of the parties to this proceeding that are affected by the trial, are not present. And that is the defense of Khieu Samphan, the defense of Nuon Chea, and in fact the lead co-lawyers who are not part of any other case than this case. And thirdly, I think this is the appropriate time, because the most important thing to us is what this witness, I apologize for using the word witness, the civil party who's testifying wants. If he came here and said, because of the intimate nature of what he's going to discuss, he does not want his name public, I would certainly understand and fully support his or any other victim's decision. But if a victim comes forward and bravely says, I want to testify in public, we also fully support that, and we think that's in the interests of the court, of the public, and of the history.
Can I just make one point? I think, and you didn't respond to that part, I think it was always understanding that the investigating judge had asked for these measures not exclusively or not only as protective measures for the witness, obviously, but to ensure the integrity of his investigation. Now, we are in no position to know how giving the name of a certain witness or not giving it impacts on the integrity of his investigation. This is why we said that's basically something that we can't litigate here. Having said that, you have mentioned the decision. If this decision of the appeals court for the co-investigating judge has said all of these suggestions are null and void, then let's read the decision and start the debate from there. But again, it's not so much an issue of protective measures. Obviously, we know the rules for that, but of the integrity of the investigation, which is an issue explicitly raised by him as a reason for that.
And that is a perfectly legitimate issue. The pretrial chamber appeal decision certainly does not say throw out the window the OCIJ's decisions or recommendations, but says they are not conditions. These are recommendations, and it's up to your honors based on reasons, and solely your honors' responsibility based on reasons, to give a reasoned decision to overcome, if that's appropriate, the presumption of a fully public trial. In regards to, for example, in particular, this witness's name, I frankly can think of absolutely no way that his name being public affects the integrity of any other investigation. I say that honestly, and I don't believe the decision from that your honors received from OCIJ provides a reason, which if your honors are going to base your decision on their belief that it affects the integrity, it has to be reason. They have to provide you with a reason, and that's how I read the pretrial chamber decision in D309/6.
President, thank you. Now I give the floor to the Defense Counsel for Nuon Chea to put questions to the civil party. You may proceed.
Mr. President, we have no questions for the civil party.
The floor is given to the Defense Counsel for Khieu Samphan. Kong Samon, thank you, Mr. President. The defense team for representing Khieu Samphan do not have questions for the civil party. President, thank you, counsels. Mr. Civil Party, as a civil party in this courtroom, you may make a victim's impact statement, if any, concerning the crimes which are alleged against the two accused, Nunji and Kheo Somphorn, and harms inflicting upon you during Democratic Cambodia from 17 April 1975 to 6 January 1979, resulting in your civil party application to claim collective and moral reparations for physical, material, or mental injuries as direct consequences of those crimes. Should you have any questions or statement to make, you can do so in this courtroom, or you can pose your questions to the two accused through the chamber.
None.
Civil party. Thank you, Mr. President. In 1975, I was a policeman in Phnom Penh. I hoped that I would remain a policeman serving my country, but my purpose did not materialize. I was evacuated from the city on 17 April 1975. I had so many suffering. After I left Phnom Penh, I suffered a lot. I slept along the road. I did not have enough food to eat. When I became sick, in Kampong Cham province, I had a fever and I did not have medicine to take. I picked up sadao leaves and pounded them and mixed them with water, and I drank them. Then I continued my journey. When I reached Pao, I went into an office of the Pao District Military Office in Pao District. They arrested me and brought me into the office. At that place, they surrounded me. There were Khmer soldiers guarding the place for many layers of guards. I was not allowed to go outside, but fortunately, I survived. I left that detention office and I continued my journey along the road. I was evacuated from Kampong Cham to Takao province. When I arrived in Takao province, I met my relatives. At that time, my aunt named Yun told me that Antat Nat, who was a military police, and another man who was a marine soldier at Chiroi Changwa, both of them were taken away by the Khmer Rouge. So two of my nephews were killed. She whispered to me that you should not talk about your background as a policeman because your fate would be the same like Nat and Hien. So you better say you are a student. So I follow her advice. The next morning, another aunt of mine named took me to see my parents near Tamon village prison in Kampot province. Over there, the village chief, the Khmeru village chief, came to check me. He inspected my clothes. I had some money from the Luno regime with me. And I also possess a student ID card, student in 3 grade. For the other cards of my final years in school, I had already thrown it away. I had also thrown away my policeman ID card. So they did not cause any harm to me at that time. But at night time, I slept and there were militiamen came to spy on me because they knew that I came from Phnom Penh. I was so terrified. I was so worried. During daytime, my mother told me that I should not talk anything when I slept because otherwise I would be taken to Tamon office. And let me tell you about Munti Tamon or Tamon office. I was there for about half month and I saw new people from Phnom Penh were sent to Tamon office and they disappeared and never returned. Later on, they kept on spying on me and they wanted to find reasons to kill me because I was considered as the new person from Phnom Penh. They constantly spied on me. At that time there was a brother who was a villager. He told my parents to take me away from the place, that we should go back to our native homeland, otherwise the whole family would be killed. Because you had a son from Phnom Penh. And I would like to tell you that my parents had been evacuated to live near the Tamon office. So when I arrived, their biographies became degraded. Later on, the Khmer Rouge allowed me to go from Tamon office to Lo Achswa village in Kampot province. It was bordered the Takao province. Over there, my pens and books were confiscated because they said that in the near future I would be sent to study. When I heard this, I was so terrified because I knew that I would be killed. Later on, I moved to live in Takao province. I lived in a mobile unit. They did not give me enough food to eat. They gave me only a little gruel. And at free time, I went to take the morning glory and I ate the morning glory raw. I did not cook it. That was when I was at the commune mobile unit. So during that time, I did not have enough food to eat. I was skinny and my health was also poor. I had a fever. And then I stayed at the commune hospital, and the commune hospital gave me only the medicines that made from cassava. My mother had some jewelry left and she used the jewelry in exchange for some medicines for me. I took those medicine and I became recovered. Later on, I was sent to the mobile unit of District 107. And over there, I was very thin. Although I was thin, I was put in a special unit. And that unit was in charge of making us carrying basket. And I also had to carry us. Although it was so heavy, I needed to do it. Otherwise, I would be in trouble. So I tried to carry us, although both of my legs were swollen and I was so hungry. When I was carrying us, I did not walk fast like other people. I walked slowly. And later on, a unit chief named Vung, who was also in the village of a Reneem commune, he was sent to spy on me. And he also asked my parents what was my job, what did I do? And my parents answered that my son was a monk. And my parents also took away all the documents about me and they burnt all those documents because they were afraid that by keeping those documents, I would be in trouble.
She grew some tobacco plant and gave it to Wong, the unit chief, and she also gave him some jewelry because she had been questioned on several occasions on the accusation that I was a former policeman, but she kept denying and she said that I was only a student and a monk. Later on, I was assigned to work to the east part of Takai provincial town, and I had a blanket with me, but they seized it from me. I didn't dare to protest. I kept on working at that location, and physically I was weak, I was emaciated, but I didn't dare to protest against the work given to me by the unit chief. By 1978, in around April of that year, the unit chief called me to meet him and spoke about the marriage that I was forced through, as I testified earlier today. I felt so sorrowful that I could not marry my fiancée, whom I loved and I wanted to live with her for life. It was like the fruit was about ripe and then it was picked and taken away from me, and I had no rights to protest against that. I felt a heavy pain in my chest, and even now when I think about it, it's beyond belief. And I scolded myself, how come I was born during such a terrible period of time? And that I had to have her as my wife, but I was separated from her. My love for her could not be described in words. We used to go everywhere together, through a religious ceremony together, through made an offering together. There were so memories between us. But in the end, I lost her. Although later on I was married, I still had feeling for her, and I was wondering why I was so unfairly treated. Even after I forced to marry, I did not love my married wife. And about a few months after I got married, my father became so severely sick, and he was transported by the Khmer rules to a hospital in Sambu commune in Trang district. It was a district hospital, and my father's body was swollen. He was hungry. He asked for food. Then they actually used water from a big jar and injected that water in him. He had seizure, and as a result, he died. This added further pain to what I had suffered. In my life, I only had a father, and when I lost my father, and when I went to the site where he got buried, it was so painful. And not long after, my aunt, who came from transplanting the rice, fell down and died. And another uncle was accused of being a soldier of the previous regime. He was sent away and killed. It's a suffering one after another that I was inflicted upon. And please, Mr. President, I urge you to prevent such occurrence, to prevent the return of such a regime. I concede that my life is a pitiful life. It's a life without freedom. And now I am old, although now I have freedom, but it's too late. Throughout the entire life, I only carry with me the pains, the sorrows, and the sufferings. That's all I wish to say, Mr. President. President and civil party, do you wish to put any questions? Civil party, my first question is the following. I refer to Khmer Rouge leaders, that is starting from unit chief up to the top leadership, that they could choose their life partners, and how could the Cambodian people be deprived of such a right? Second question, why Angka did not allow me to marry my fiancée? She did not commit any mistake. It was her other brother who was accused of committing a mistake against Angka's policy. These are the two questions, Mr. President. President, thank you, civil party, and please be informed that thus far the two accused still exercise their right to remain silent. And the hearing of testimony of a civil party to TCCP 232 is now concluded. And Mr. Civil Party, the Chamber is grateful of your time and testimony as a civil party. You may be excused from the courtroom, and court officer, please work with Visu to make transport arrangement for the civil party to return to his residence or wherever he wishes to go to. And I'd like to hand the floor to Judge Fans.
Yeah. This is basically to ensure the prosecutors that will obviously deliberate on the issues you have raised, will review the decision D3096 and get back to you in due time. Let me just clarify if I understood your request correctly. You are basically requesting to ignore the categories, the requests for categorization and the accompanying measures by the co-investigating judges, provided they are not either based on protective measures or specifically reasoned in case the reason is integrity of the investigation. Did I summarize that correctly?
I wouldn't use the word ignore, but I agree that you should consider them to the extent that they give reasons for why the integrity of the investigation could be affected or protective measures necessary. And again, we're only requesting the lifting of pseudonym for those witnesses who also do not request a pseudonym. If the witness requests it, we would support the witness.
Is this exclusively dealing with the pseudonyms? Because that's a bigger issue. I mean, these disclosures come basically under the condition that we respect the three categories and the accompanying measures that the co-investigating judge suggests in each case. So are we discussing a revisal of the whole scheme, or are we only discussing the very limited issue of category A, civil parties or witnesses, which usually only means pseudonym instead of name?
My suggestion is, or our position is, that when your honors get disclosures with these indications from the OCIJ that protective measures or even closed session should be used, you would evaluate that. If the reasons are lacking, I think it would be certainly possible to ask to mention that to OCIJ and ask if they have further information they could provide as to why they believe the measure is necessary. But absent reasons for the protective measures or closed session, our position is that the law requires you to have the proceedings in public. The accused, and we say the public and ourselves, are entitled to a public trial.
And so far we haven't had a case where we have shut out the public. So
that's absolutely correct. And I would just point out that there was one, as you know, a couple witnesses where there was closed session. I believe I'm allowed to say that. The transcript's been redacted and made public. We don't think, I could be missing something, but I don't see what was gained by that other than the public losing the opportunity to hear very critical evidence.
The Chamber will adjourn today proceedings now and resumed on Monday, 29 August 2016, commencing from 9 o'clock in the morning. On Monday, the Chamber will hear civil party through TCCP 219. And the scheduling for next week proceedings will be sent to parties in due course. Please be on time. Security personnel, you are instructed to take the two accused, Nunchi and Kirsampon, back to detention facility and have them return to attend the proceedings on Monday before 9 o'clock. The court is now adjourned.